Get out of the car. I'm going to give it to you again. Get out of the car!
Stop reaching! Stop reaching! Let me see your hands! Let me see your hands now!
She's got a crack pipe in her hands.
On August 11th, 2024, somewhere in Florida, a routine traffic stop exposed a cascade of poor decisions and a set of legal standards that every driver in this country should understand.
What direction?
We're eastbound. I'm trying to get the fix on it. Wait a minute. I'm gonna get sticks in the roadway here on 18. He's still eastbound. Coming up to 9.
Show me your hands. Show me your hands. Get out of the car.
Get out of the car now! Get out of the car!
Get out.
Get out of the car! Get out of the car! Put it in drive! Let go of the car! Get out of the car now!
Get out of the car. Stop. Stop. Stop.
Car! Get out of the car! Get on the ground! Get on the ground now! Get on the ground now!
Get out of the car.
I can't.
Get out. Hey, put it in park.
I can't!
Get out of the car.
Oh my God!
Get out of the car. I'm going to give it to you again. Get out of the car.
Stop reaching! Stop reaching! Let me see your hands! Let me see your hands now!
She's got a crack pipe in her hands. I got the keys. Get on that side. I got the keys.
Get out of the car now! Get out of the car now! Get out of the car now!
Here, let go. Let go. Let go. Get out of the car.
Hey, stop. Give me your hands!
Still fighting radio. We're simple.
Give me more radio now. Put your hands behind your back. Get that guy over there on the south side. South side. He's in cuffs. All right. I got you. I got the crack pipe. Let go of the crack pipe. Let go of the crack pipe. Stop moving. Stop grabbing me. We're 15, release it. Here's the crack pipe she had in her hand. Thank God.
Get over here.
The first legal issue is the vehicle exit command. Under Pennsylvania versus Mimms, decided by the U.S. Supreme Court in 1977, an officer conducting a lawful traffic stop has the unqualified authority to order the driver out of the vehicle. That authority was extended to passengers in Maryland versus Wilson, 1997. No additional justification is required. The moment you refuse a lawful exit command, you are no longer in a gray area. You are actively resisting a constitutional police order. The second issue is use of force. Officers deployed a taser, not once, but twice. Under Graham versus Connor, 1989, courts evaluate force using 3 factors: the severity of the crime, whether the subject posed an immediate threat, and whether they were actively resisting. All 3 factors were present here. Fleeing from police is a felony under Florida Statute Section 316, 1935. Reaching inside a vehicle during a confrontation creates a legitimate officer safety concern, and refusing to exit for over 90 seconds is textbook active resistance. Under that three-part Graham framework, the taser deployment was legally defensible. Courts do not judge force with hindsight. They judge it from the perspective of a reasonable officer, with the information available at that exact moment. The third issue is the plain view doctrine. When an officer observed a crack pipe in the subject's hand, no warrant was needed. Under the plain view doctrine, contraband that is immediately apparent during a lawful encounter is subject to seizure without additional legal process. Florida Statute Section 8, 93, 147, subsection 1, criminalizes possession of drug paraphernalia, combined with Florida Statute Section 8, 93, 13, subsection 6A, on possession of a controlled substance. The evidence in plain view was sufficient to support probable cause for arrest on multiple counts.
Hold on. Yep, gotta be searched. Yep. You got your work phone on you? Yeah. Grab your work phone, photograph the probes. I got her.
What? Who's bleeding?
No, Kathleen. Was that Kathleen?
I don't think so. Whose car is 1725? Just put him over here. Well, that was quite not smart, was it? Not smart at all. Told you what?
She told me to go.
Why? Why would you do that? Because look what happened. Do you have anything else on you or inside of you?
No.
Who is she to you?
Friend?
Can you do me a favor and test this for crack, please? Yeah. Excuse me. Do you have anything in your shoes?
No.
Anything that she's missing in the search that you don't want to find in jail? I'm asking you now.
No.
Politely. Yeah, we're good. Thank you. Thank you. Yeah, so he originally fled a traffic stop from her.
Yeah, I heard that.
Yeah.
Take a seat still facing me and kick your shoes off, please.
Got anything tucked up in your bra or anything like that? No.
I don't have a bra on.
Alright. Get in the car. Take a seat.
Alright, you have the right to remain silent. Anything you say can be used against you in court of law. You can talk to a lawyer and have him present with you while you read questions. If you can afford to hire a lawyer, one will be able to represent you. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand each of these rights I have explained to you?
Yes.
Having these rights in mind, do you wish to talk to us now?
I'll talk to you now.
Okay, so that's a yes?
Yeah.
Okay. Why did you run?
I didn't ran. She told me to go. I tried to stop. She keep messing my gas. I said, go. I tried to stop right there on 13. She said, go.
Who is she to you?
That's a friend.
Why'd you listen to her? Is there anything in the vehicle?
Yes.
Yeah?
A bill.
There's a what?
Bill?
A bill?
Bill.
Bill.
Like Budweiser, that's an ice bill.
So alcohol?
Yeah, bill.
Have you been drinking?
Yeah, about one bill.
What's one bill? Like a tall boy or a...
Light.
Okay. So one Bud Light?
Yeah.
Okay. What did she have on her? Why did she not want you to stop?
Because she had all her shit on her. I picked her up, she said, take me over there.
Where's over there?
Oh, Seminole, somewhere over there.
She wanted you to drop her off over by Seminole?
Yeah.
Where at?
Seminole at about 21st or 20.
Where'd you pick her up from?
Oh, 7 and 28.
7th Avenue, 28th Street?
Yeah.
And then she wanted to be dropped off Seminole where?
Somewhere over there on 20.
On 20, what?
Seminole at about 21st or 20.
Okay, why'd she want to be dropped off there?
Get some drugs or something.
You think that's why, or you know?
That's why.
That's why? Because
Yeah.
she wanted to get drugs? What kind of drugs?
I don't know, hard. Hard.
What's that?
Rocks.
Rocks?
Yeah.
Okay, did she say who she was going to get it from?
Nope.
No. Is this your vehicle?
Yeah. I live right on the corner.
The fourth issue is Miranda. Under Miranda versus Arizona, 1966, law enforcement must advise a subject of their rights before any custodial interrogation begins. Officers did read the Miranda advisement to both subjects before asking questions. That part of the procedure was handled correctly. But what happened next is where things get costly. The male passenger waived his Miranda rights and agreed to speak. In the minutes that followed, he admitted to drinking alcohol before driving, confirmed his passenger had narcotics on her, and volunteered that she intended to purchase crack cocaine near Seminole Avenue. Every word of that was admissible in court. A valid Miranda waiver makes every voluntary statement prosecutorial evidence. The female subject made the smarter call. She invoked her right to remain silent, and questioning stopped immediately, as required by law. Now, the grades. The officers receive a B+. They issued repeated verbal commands before escalating force, administered Miranda to both subjects before questioning, documented the crack pipe on camera, establishing chain of custody, and correctly honored the invocation of silence. The minor deductions come from an unresolved injury question on scene, which triggers mandatory medical evaluation obligations, and a brief moment of editorial commentary to a restrained subject, which, while understandable, creates unnecessary documentation risk. Overall, a professional response to a volatile situation. The female subject, the driver, receives a D. Directing a driver to flee from a lawful traffic stop is not a gray area. Under Florida Statute Section 316, 1935, subsection 2, that conduct alone constitutes aggravated fleeing, a third-degree felony, and it triggered every consequence that followed. The one point in her favor: she invoked her right to remain silent when asked to speak. That was the correct legal move, and it was the one decision in this entire encounter that could not be used against her. The male passenger receives a C-. He was behind the wheel. Social pressure from a passenger is not a legal defense under Florida law. He then waived Miranda and talked, which converted what might have been a limited role into a documented admission of knowledge about ongoing drug activity.
Okay, what's your name?
Reggie.
What's your full name?
Reginald.
What's your last name?
Ellison. E-L-L-I-S-O-N.
I-S-O-N. What's your date of birth?
9/17/61.
What's the last four of your social? Okay. What's your name? Hello. Did anybody read her yet?
Anna, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him or her present with you while you're being questioned. Do you understand each of these rights I've explained to you?
Yes,
and having these rights in mind, do you wish to talk to us now? Do you understand your rights, Anna?
Yes, ma'am.
Do you wish to have a conversation about tonight?
I mean, if you guys need me to.
That's up to you. Having these rights in mind, do you wish to have a conversation with me? No? Okay. Lock!
Every encounter like this carries lessons, and this one is no different. What follows are 5 takeaways that apply to anyone who ends up in a traffic stop, regardless of the circumstances. Lesson 1. Comply with vehicle exit commands. Pennsylvania versus Mimms and Maryland versus Wilson are settled law. Refusing to exit does not protect your rights. It escalates the force continuum and puts you in a legally indefensible position. Lesson 2. The person in your passenger seat can determine your outcome. The driver in this footage had no prior reason to run. His passenger made that decision for him. Under Florida law, that was enough to put him in handcuffs. Choose who you let in your car carefully. Lesson 3. Understand what a Miranda waiver actually means. Agreeing to speak after Miranda is not a casual conversation. It is a formal waiver of your constitutional Fifth Amendment protection. Every statement you make after that point is evidence. If you are in custody, consult an attorney before you speak. Lesson 4. The plain view doctrine has no exceptions for bad timing. If contraband is visible to an officer during a lawful encounter, it is seizable without a warrant, full stop. Florida Statute Section 893. 147 makes possession of drug paraphernalia a standalone criminal charge, independent of the underlying substance. Lesson 5. Invoking your right to silence is always available, and it is always the correct move when you are unsure. The female subject in this footage made one smart decision in an otherwise damaging night. When she said no to questioning, questioning stopped. That is how the Fifth Amendment is supposed to work. This footage is a compressed version of how one decision, made in seconds, rewrites the entire legal exposure of everyone in that vehicle. The law does not grade on effort or intention. It grades on conduct, and conduct is exactly what the camera records. If you found this analysis useful, subscribe to our channel for more legal breakdowns of real bodycam footage. Drop your questions or the cases you want analyzed in the comments below. Every video is built around helping you understand the law before you ever need it.